Thank you for joining us. I want to thank especially George Anthony Long for putting this together, and our esteemed panelists who I think I'm very excited to hear from. As some of you might have seen, those of you on social media saw that this topic has generated a tremendous amount of interest. We're going to really sort of hone in on due regard and look at different perspectives of it. We are going to use the Q&A function, so if you have a question, throw it in the Q&A, and I will be sort of moderating those questions. For the most part, though, we're going to start off the discussion with some thoughts from our panelists. I know that I'm seeing a lot of familiar names here, and a lot of you are lawyers, so and a lot of you are already very familiar with the Outer Space Treaty. But I just want to sort of put us all in the same frame of mind. Here in Oxford, it is 8 o'clock in the morning, so it helps me just to center. But, we're talking about a treaty that was ratified in 1967, and we're talking about a treaty that the fundamental precept of which is freedom of exploration and use, right? And so that is the underlying theme with respect to space law, freedom of exploration and use. And I welcome my panelists to disagree with any of my statements. What we see in terms of narrowing that freedom, right, is not a lot in the Outer Space Treaty. We see that the exploration use must have shared benefits, okay? We see that space, that we have that freedom of exploration use, but space is the province of all humankind, whatever that means, right? And then we have Article 2. You can't, a state party may not claim territory in outer space by sovereignty, by use, or by any other means. Article 3, international law applies and can also limit our freedom of exploration and use of space. Of course, Article 4 is our most sort of commanding. We will not place weapons of mass destruction or nuclear weapons in space. But then again, we see that it is the moon and the other celestial bodies shall be used exclusively for peaceful purposes and not necessarily space. We have obligations of liability. We have ownership, registration, we have an obligation to rescue, and then we have Article 9, which is the topic of our panel today. Article 9 offers two distinct, we're not going to talk about harmful contamination, that's largely covered by or largely agreed to be covered by COSPAR. So we're going to really focus on due regard. You will conduct your activities in space with due regard for the corresponding interests of others, and harmful interference. And again, in the Outer Space Treaty, it doesn't say you will not harmfully interfere. It says if there is a potential for harmful interference, then you should have a consultation. And so again, looking at the words, the lawyers here, those words, and it's always said, parties can agree to the words in the treaty very easily, not so much really, we know, but it's very difficult to agree to the interpretation of the treaty thereafter. And so that's really what we want to get into, is that interpretation of the treaty. So with respect to due regard in particular, it's been said that it's a duty of self-restraint in exercising the rights given to all or multiple states, that it's a balancing mechanism, hence the yin and yang, right, between states with identical rights, and that the duty of due regard is satisfied if a state exercises rights without resulting in unjustifiable interference. And so we see now that interaction between due regard and harmful interference. And that's another thing we want to explore with this panel. This concept of due regard first appeared in the 1944 Convention on International Civil Aviation, which provides that state parties undertake that state aircraft shall have due regard for the safety of civilians, of civil aviation. The term due regard is found about 10 times in the United Nations Law of the Sea Convention, among which the references to the high seas freedoms that shall be exercised with due regard for the interests of other states. And we have one arbitral panel which has come up with a concept of due regard, and they've noticed that it's the Chagos Marine case, which I'm sure many of you are familiar with, which declined to find a universal rule of conduct and set forth this concept of due regard as a balancing test, looking at the rights of the states, the rights that have been infringed, what can be done, what cannot be done, what could have been done to prevent the interference, and so forth. So we have this concept, and it's not been applied to space activities as yet, not formally. And all we have is this balancing. Now we know balancing tests as attorneys give us a lot of free rein, right? We can argue the balance of the rights and obligations for decades. We see that happen all the time in the United States. And so that is not a great way to move forward. And so the question that we want to really explore is what does due regard actually mean? How can we implement a due regard regime at an international level that will actually promote the exploration and use of space peacefully? And so that's enough for me. I'm going to start off. I am not going to introduce my panelists with their full profiles and bios, because that would take the full 90 minutes of our panel. But I just want to I know that many of you tuned in because these are very familiar figures to you. So I'm going to start with Franz. The title of this webinar labels due regard and harmful interference as the yin and yang. How would you articulate the relationship between due regard and harmful interference?
Well, I think the title, in a sense, already gives the main idea, and you added the most important elements to it already in your introduction. I think both terms, due and harmful, are so open to interpretation that it's very difficult at this stage to say at any reasonable level of how they interfere or interact. They are, in a sense, two sides to a coin. Although they are not exactly mirroring each other. My general problem with this is that we need a lot of state practice, not necessarily in the customary international law sense, but state practice in general, to give ourselves an idea of what harmful is and what due regard is. Think about pedestrian crossings. Everybody knows that if you drive a car and you approach a pedestrian crossing, there's a certain quite small range of what due regard means. If you see somebody intending to cross the crossing, you take your measures to be able to brake if necessary. And that's because almost every one of us has driven a car across a pedestrian crossing hundreds of times and has been a pedestrian himself or herself hundreds of times. So you have a fairly good sense of the margin of what due regard for a pedestrian interested in crossing is. We don't have anything like that in outer space. That's why this seminar essentially is kind of a starting point for a more thorough discussion. Because if you look at it, there is not much in terms of real legal debate about specific interpretations of due regard in a particular context. I stop there at the moment because as the program goes on, we will probably touch upon some specific instances like what is due regard when it comes to operating in the vicinity of another satellite, what is due regard when it comes to operating close to a facility or a habitat on the moon. But again, I'll stop there for the moment.
Thank you, Franz. So, Guoyu, Franz also brought up a different concept, two sides of a coin, yin and yang. What are your thoughts in terms of the relationship between these two concepts?
Thank you, Michelle. And again, I have to say it's a super honor, to attend this discussion, and this super opportunity for me to share my personal views with I think most of the coming from just our international colleagues. So as back to the question, so I think maybe many people just take it for granted, due regard just means, or we say its connotation includes non-harmful interference. But I'm afraid it's not necessarily the case. That's the difficult part. So first, I would like to say outer space treaty per se does not, excuse me, expressly stipulates, say, non-harmful interference, or say avoid harmful interference. So this term actually is one of the preconditions to trigger the obligation of a prior consultation. Space lawyers know that, of course. So as to obligation, non-harmful interference is not an expressly stipulated obligation, but it's something for us, for most of us, I think is something which we should try to avert, to try to avoid, such kind of things happen. Then I just mentioned at the very beginning, maybe it's not necessarily the case because space activity, includes, we say, peaceful use of outer space and the arms control matters, or in other saying, it includes civilian, commercial, as well as the military space activities. So what would be the boundary or the margin, as you said, to achieve the balance among the different interests? I think the answer might be different when talking about commercial activity or military activity. And you just also mentioned do you regard the I mean, just by analogy, the saying in the aviation law, it's just said shall have due regard for the safety of civil aviation. But you see, space does not say in the same way. Instead, it's talking about corresponding interests. So it's a very subjective, actually, matter. It means that safety, super important, of course, but it's not supposed to prevail in any cases. So that's a difficult part, particularly concerning the geopolitical tensions. So we can back to the details later on. I just stop there at present. Yeah, thank you.
Thank you, Goyu. And I did this reminding that we're balancing very different interests when we talk about due regard. And so, that concept of corresponding interests is really curious because, what in essence does that mean? And I think we will get into more specifics as we explore scenarios. So Jeremy, yin and yang, due regard, harmful interference, what are your initial thoughts as we embark on this journey through due regard?
Sure. Well, thank you. And thanks to the conveners for this panel and everyone who's been joining. Standard disclaimer of speaking in my personal capacity, not necessarily views of the U.S. government. I will say maybe yin and yang I will leave to others. I won't attempt any interpretation or mapping or correspondence there. On some of you said at the top of we're not talking about avoiding harmful contamination, adverse changes to the environment here. I would actually back up and say that that there is a relationship between that sentence and due regard, and it's very similar relationship as I see it to the potentially harmful interference provisions. So I would look at due regard as, and even before that, we say shall be guided by the principle of cooperation and mutual assistance. And then we have sort of two examples, manifestations, illustrations, however you want to call it, of the due regard principle concept in play. So we have that avoiding harmful contamination or conducting studies about avoiding that, avoiding adverse changes to the Earth environment. And I think that is an example of acting your space activities with due regard for others. At the same time, so is consulting about if you have reason to believe your activities would cause harmful interference. So I do think there's an important relationship there. And acting, maybe it's a bit circular to say, well, acting with consulting in these circumstances is an example of acting with due regard, but we can be circular. We're just on a panel, right? So I guess that's what I'd say for now. Thanks.
Thanks, Jeremy. So I'm going to dig right into it, Franz. You were talking about sort of getting to specifics and scenarios. So when I think at low Earth orbit, when I teach this in my classes to students, We think about ASAT tests, right? Destructive ASAT tests. And how is that showing due regard for the corresponding interests of other states? And, when we look at, for example, when China sent the note verbal to the United Nations about the Starlink satellites that were potentially interfering with Tiangong, they didn't invoke due regard. They invoked Article 5, return and rescue. There is an issue, you are putting our astronauts, our taikonauts in harm, potential harm. So how do you see the implementation of this concept of due regard in orbit when it seems like everyone is afraid to invoke it?
Well, that's a great point. And I think we need to realize that if you use in international law terms like that, the baseline is the underlying question is who decides what due is in a particular case of due regard, and who decides what harmful is in a particular arguable case of harmful interference. I mean, again, to keep the two sides in play here. So the normal answer in international law is, of course, that if this is an international legal obligation, and Michelle, you pointed out, of course, that they are both enshrined in the Outer Space Treaty, which is a treaty signed and ratified by all states who are anywhere important in the context of space. So it is an applicable treaty. The first answer would be, well, it's up to the treaty to define what it is. But since the treaty doesn't do that, then it goes down one level to sovereign states interpreting that. But we always have to realize that individual interpretations by states are open to adversary criticism, and then in a perhaps, I hesitate to say that, but in an ideal world, when it would be brought before an international dispute mechanism, that's where the decision falls, whether the state doing something is actually taking due regard, or whether it does not comply with what's supposed to be due regard at this point in time, or whether the state which is complaining about a lack of due regard or complaining about harmful interference is in the right position. And so far, states are reluctant, precisely because of the lack of frequency of events, to make any statements which then can be held against that. Michelle, you mentioned interference by means of ASATs. We've seen a number of tests which could, or a number of activities over the last decade and a half or 2 decades, which could qualify as ASAT tests. We had the Chinese in 2007 and the US with USA 193 a year later. We've seen more recently the Russians and the Indians doing similar stuff. So does that mean that these countries can go ahead regardless, because apparently they don't have any regard? Is due regard a measure of a kind of an obligation of intent, of effort? The least you can say about the US effort in 2008 was that the US government, prior to actually undertaking the shooting down of USA 193, did inform the rest of the world, did try to argue and explain why it was important. Whether they claimed that was due regard or not goes back to your point that states are very reluctant in this totally novel world to make a legal statement like that, which then later can be held against them. So I'm not sure that we are going to go very far unless we have some form of dispute resolution, whereby a judge or a court or an arbitral tribunal, you may think about the PCA, optional rules for arbitration, has to come to an announcement in a particular dispute. This is compliant with due regard or not, and or this is harmful as interference, or it does not rise to the level of harmful interference and a violation of the obligation thereof. And only at that point we can start to hone in on a more specific interpretation. I'm not sure whether that's a complete answer to what you wanted to know, but that's at least my first pennies of worth for it.
So I'm gonna why do you think, or do you have a theory as to why the Chinese government would use? Is it just as Franz said, Article 5 instead of Article 9?
Thank you, Michelle. I think I just feel 3 hours maybe not enough for us for that. But this is regarding the legality, as you said, ASAT test is a difficult question, particularly for Chinese. But I just speak on my own. We are not supposed to be, I like France's position there. Of course, we're not supposed to be like a judge from ICJ to say legality, the internationally wrongful act from which side. But I have to say, I think it's very important for our lawyers, even for copious, people. When people talking about safety of a space activity, safety of a space system, protection of space environment, space debris mitigation, of course, it's super important. There's so many good will behind them. But people should not forget the starting of the space activity. It's just from military concerns. So as the main drafter, USA or Soviet Union, the main drafter, of course, one of the main drafters of Outer Space Treaty, they are not supposed to, to leave a bomb. You know what I mean? There, or they just drafted an article which would be definitely violated by them in future. I don't think so. So that's what the international law we have, space law we have so far. It means flexibility, many or maybe uncertainties there, room there to be interpreted, to be argued by each side. So that's the first point. And the second one, in practice, I mean, US and USSR just conducted maybe more than, as it's different number of different records, of course, 15, maybe 15, more than such kind of is a test. But yes, you are right. And France also mentioned that, followed by China, and then US another one, and India and Russia Federation, of course. So for our lawyers, sometimes it's difficult. Maybe for the IR person, international relations people, I think it might be clear, because such kind of a test, it also means right now to most of us is a threat, right? Because it generates thousands pieces of space debris. It's bad. But from the IR theory, threat also means deterrence. So that's the point. Deterrence, what can I say? Sometimes it just plays a super important role to keep the stable world for all of us. So I would not like to argue defense for someone, but they must have very strong reason from, security reason to do so when they made such kind of decision. So, but whether it should be justified, that's another topic. It's about, again, the balance of different interests, the deterrence there, whether such kind of a behavior could, promote stability of the world. If so, unfortunately, we have to tolerate about that, even for our lawyers. So that's it. So that's the first point. I just allow me to take a bit more time on this. And the second point, you mentioned the implementation, how to implement the due regard obligation in outer space. Actually, it's also a matter of interpretation. It's also important thing which has been, neglected for a long time, no matter in Vienna or Geneva, particularly for the diplomats, arms control diplomats, because they are not lawyers. They are not familiar with the Vienna Convention. They're not familiar about Article 3, like paragraph 3, A and B. So the subsequent practice, subsequent agreement also could be deemed as maybe a legal position of one country, one delegation to interpret particular obligation, for instance, due regard. And during, Jeremy also participated in the Responsible Space Behavior, OEWG, last session. The delegations there, actually, they proposed some recommendations, and most of them are about, say, states should refrain from intentionally conducting, say, harmful interference, no matter it's about laser dazzling, coorbital like approach, RPO, or jamming, spoofing, such kind of things. So it's super important because it's very relevant for a lawyer. It's very relevant to the implementation or interpretation of due regard. So, but the delegates there, unfortunately, they did not realize they are doing the interpretation thing. They are just, they were thinking about, they are bringing something new about how to judge responsible and irresponsible. But again, it's just coming far away from the rule of law spirit. So that's my personal observation there. The implementation of due regard should be developed, clarified through some kind of international negotiations, no matter in Vienna or Geneva. But people must know what they are doing are very relevant to interpretation, to the law of the treaty. So that's my thinking so far. Thank you.
Again, and actually that terrifies me, what you said, because you basically just said, well, any good lawyer, any good can argue that ASET test does show due regard, because it's a balance, right? It's not don't cause harmful interference. It's, well, what are the corresponding interests of other states? And the corresponding interest is to keep peace on earth by showing that we can defend ourselves. So does that, Jeremy, can you give me comfort?
I'll give you an argument that stability, peace, that corresponding interests textually in Article 9 seems to be referring back to activities in the use and exploration of outer space. And I don't know the exact words, but I'd argue maybe corresponding really is it's a bit narrower. It's talking about the use and an exploration of outer space. Is a geopolitical stability interest on Earth actually corresponding to that, to such a behavior, to such an action of the DASAT? I think you could make an argument that it's not. And lots of interesting discussion points here. As Goyu was saying, and this at least I hope is not the terrifying part. I think it's very important that this idea that that the state parties to the treaty, that whether they're sort of in thinking of themselves as state parties to the treaty or not, maybe they're constituted in the OEWG, maybe some of those aren't state parties, but as what you said, a lot of the concepts that are being talked about, RPOs, GAASATs, and so on, really can be seen through this lens of due regard and potentially harmful interference that is not often invoked in the rooms or in national statements. I think the points made about states' sort of reluctance about taking legal positions may be a valid one, but it doesn't mean that it's not sort of factoring in. And so I would posit that sort of state practice, international practice commentary as another way, and I guess from my perspective, a preferable way and sort of a more realistic and near-term way of sort of adding some flesh to these concepts as applied in specific factual scenarios, as distinct from sort of a dispute resolution mechanism, an arbitral tribunal pronouncing here's what due regard means. States and groups. I was not part of the long-term sustainability guidelines discussions or things like that, but those are probably there's a backdrop certainly there of due regard and avoiding potentially harmful interference, whether it's stated or not. And so I think we can look to a lot of those type of non-binding instruments, conversations as proceeding sort of with due regard harmful interference as a backdrop. And then I think panels like this are great because maybe it brings some of it more to the forefront. Over.
Thanks, Jeremy. So Franz, back to you. And I know that you want to respond to some statements that were made, but I also wanted to point out just that you talked about the flexibility of due regard. You said, is it due regard at this point in time? And I think that's really a fascinating sort of take on and sort of reinforces the need to have an adaptive framework here. But please go ahead.
Yeah, no, following on to that, you asked whether I could lay your worries to rest. Unfortunately, I'm not able to do that, partly because the current geopolitical climate is, as we all know, not as conducive to agreements on these very fundamental issues. I mean, even apart from the fact that we're just entering this discussion in any detail. But at least I can offer you a little bit more of a long-term perspective. This is going to take time. It takes time for states to realize that, in a sense, they're all in the same boat together, that we only have one planet Earth, to put it in some sort of a, metaphorical context. They are testing the waters. They are finding out what can we safely say. And if you compare it, for example, to a closely correlated issue of space debris and the total lack of regard for the risk of creating space debris, which ruled space activities up to, let's say, 2 decades ago, that is now changing. And again, it may take a generation, unfortunately, which is very long. But once states started to get deeper into the game, there might be still some convergence on a specific notion without the need, as Jeremy points out, for a hard and fast legal settlement to actually solve the issue. Because I do agree that's not probably realistic either in the short term. So in the long run, there are some pointers which may force states to agree, in spite of their widely different short-term political interests and strategic interests, to realize that it's in everyone's interest, just as it is in everyone's interest to tackle the broader issue of space debris. And that's also, I guess, why Jeremy brought in the long-term sustainability guidelines. They may provide a first platform for arguing in a concrete case what you're doing now. How can you still qualify that as due regard if we all know how vulnerable low Earth orbit environment starts to become and things like that?
Did you want to add something?
Yep. Yes, Michelle?
Yes.
Yeah. Yes, just some hot pursuits there. So the first one, actually, I forgot to mention the Chinese space station, that diplomatic note, that part. And you asked me whether no matter why China just did not mention Article 9. So again, to be honest, I was not consulted about the wording at that time. But as my understanding, Article 5 was mentioned because it's relevant to the life or the safety of astronauts there. That's the super, I mean, important concern. And as to why, because it's also a very legal question, an interesting question, because that approaching was conducted by a commercial actor, not by the government. So the due regard, then the legal question would be, who is required to conduct due regard? So again, back to the specific wording in Article 9, actually, I believe is very relevant to the government. It's about a governmental thing. Then how to assure the commercial non-governmental entity also follow, because there are another saying, Article 6, right? So the government has an obligation to assure the national activity carried on by non-governmental entities must be in compliance with the articles in this treaty. So I think then it's a matter about the transit of international obligation in domestic law. So for China, for my government, I think maybe it's not very accurate to say SpaceX just violates due regard. It's not 100% correct legal saying there. Or if I was consulted, I might suggest to say it's about the United States violate the obligation of assuring, something like that. It's not about due regard. There's something you see, need some bridge there. That's the first point. And then the second point, because Jeremy also mentioned the LTS guidelines, I just participate all the discussions in the 8 years as a chance expert, because it started from STSC, Scientific Technical Subcommittee. So the guidelines, the wording there, just more focused on the technical aspects, how to share information about the space debris, how to enhance the practice about space debris mitigation, how to conduct, say, prior conjunction assessment, of something. And due regard is not particularly, expressly mentioned there. And people there, including myself, at that time, we did not realize what we are doing is relevant to interpretation of due regard. We thought it's just on a voluntary basis, it's a soft law, it's just a copious document, or at most it's a UNGA resolution. We did not realize for the people there, less lawyers there. So most people coming from space agency, right? From industry. So that's the second point. But today, when I look back the wording, I realized some of them could also be deemed as example for interpretation, or the subsequent practice under the Article 31 of Vienna Convention. But again, it's another matter. And the last point, I think, so I just hop through, but again, I just follow the instruction of you, Michelle. I stop there.
So thank you. And one thing I just want to point out, and I don't know how this word is translated across the 5 UN languages, but in the US version of the Outer Space Treaty, the language in Article 6 is conformity with, and which feels like something less than compliance with, in terms of how the obligations of the treaty trickle down to private parties and nationals. Just for those of you who don't know, I just want to note that the LTS guidelines, the guidelines for long-term sustainability of space activities, was the last sort of non-binding soft law that came out of the Committee on the Peaceful Uses of Outer Space. It was agreed to in 2019, just prior to COVID, and I herald it as a big victory. I do think it's really interesting that you didn't, as you were working through, you didn't think about due regard. Of course, that's all we think about now. But maybe it's a good thing, because maybe due regard is coming from the people who actually are the engineers and scientists, and not from the lawyers who are thinking, oh, how am I gonna manage this or manage that? But Jeremy, the United States seems to have taken a stab at trying to find a balance, or define a balance, or figure out what a balance might look like with respect to the coordination of lunar activities. And the Artemis Accord Section 11, which is quite long, talking about these notification and coordination zones. Can you talk a little bit about that?
Sure, thanks. And maybe let me first just circle back on a couple points made. Just a quick reaction on conformity versus compliance. Not sure there's a distinction there. I'm thinking that a private actor would, as a private actor, in and of itself, it wouldn't have an obligation under the treaty. The obligations run to states parties. And so maybe conformity is another way of saying the same thing, but embracing sort of all the actors. But as Guoyu points out, as all of us know, Article 6, which could be a whole nother webinar, and don't want to go too deeply there, but it has, of course, the obligations related to national activities, whether they're carried out by governmental or non-governmental actors. So very fundamental there. I think also on we're talking a lot about legal interpretations of due regard, potentially harmful interference, but all of these questions are going to be very fact specific and complicated, and there may be different judgments, there may be different models, and so on, and which I think is another good reason, and it's all evolving with more state practice and technology and more missions and so on, which to my mind is another good reason for there to be sort of international conversations in all sorts of modes about what may constitute safe practices, responsible behaviors, because we don't need to sort of jump straight to, it's a violation of due regard. Well, these questions are going to come up. Well, was there even potentially harmful interference, or did you? There are a lot of sort of threshold factual questions, which I think make whether it's about approach toward the Chinese space station or any of these circumstances very difficult to sort of, you can't analyze them legally without analyzing them factually, I guess is what I would say. Could say more about DAA sat, maybe just to note that one could view that the 38 commitments, national commitments that have been made to date about countries committing not to conduct such tests, and this happened. The UN General Assembly proposal arose certainly not long after the most recent, after the Russian DAA sat test. Is that a legal outcome? No. Is it an outcome? Is there a relationship? Probably. And maybe that's maybe one could take that as an indicator that at least states that have announced such commitments don't see that as sort of a corresponding interest. So space debris, whether it's through DAA set tests or otherwise, obviously sort of can affect all states in space. You asked about the Artemis Accords and pointed Section 11, which is, I think, indeed an example of what we're talking about here with due regard, harmful interference. Very interesting what Goyu said about sort of those concepts and terms not generally being an explicit backdrop, at least in the LTS discussions. Certainly in Article 11 of the Accords, they are the explicit backdrop to an Article 11, Section 11 of the Artemis Accords, for those not familiar with it, about deconfliction of space activities, and as Michelle said, laying out sort of the beginnings of safety zones, concepts and practice, therefore, and then beyond, and then this is being taken forward further in conversations among the Artemis Accord signatories, more than 40 already, and they're working on how do we flesh this out more beyond the Artemis Accords? What are the types of information that should be reported, notifications made, and sort of fleshing out the concepts of safety zones. And again, it's situated very expressly within due regard and harmful interference.
Thank you, John. So I'm gonna sort of put on hold this concept of how we answer these questions, and you noted that everything's very specific, and like I said at the beginning, when you have a very fact specific legal standard, that just means the lawyers are going to get a lot of money as they just continue to argue this back, all the way up through appeals and back down, and that might be good for us. I don't know that, but I would rather see the money go to exploration than my pocket, but okay, maybe not, maybe your pocket, not my pocket, but but before we move on from the Artemis Accords, I just, Goyu, can you talk a little bit about the International Lunar Research Station? Are there any concepts of due regard as part of that sort of alliance, if you will?
Thank you, Michelle. Yes, I believe CSA just announced like a statement maybe 2 years ago, then followed by some also declaration as to the, how to say, the principles regarding this lunar space station there. And most of them actually are about to maintain, say, the peaceful purpose, or to highlight the significance of international coordination, cooperation, and to show its openness to all, including states, non-governmental entities, just show the very basic position. And also, as to some specific saying, actually, most of them are about information sharing or data sharing, or the share the results of such kind of exploration activities. But I believe, again, due regard is not particularly mentioned there. So that's the, but as I know, my colleagues, they're also considering to draft something. And as you said before the opening, the UN Lunar Sustainable Lunar Activity Conference will be held several days later, in Vienna, and people there, I mean, coming from China, Russian Federation, some other countries in the space station project, and some others coming from Artemis Accords as its signatory states. People would share their views and their maybe legal position there, hopefully. Let's see what would happen at that time. But personally speaking, because I participate, again, almost all of the international initiatives in this case, the Hague Working Group on Space Resources Governance and the Gadgets Law project. Also, personally, I involved in the discussion about the Artemis Accords 4 years ago, with also our dear colleagues like Mike Gold and Gabriel. We also had several webinars as to how to promote the tests in Artemis Accords. So what I'm trying to say is that, again, as a lawyer, neither of the international initiatives or the outcomes could satisfy all the needs, from international society to promote lunar activities. All of them need to be developed, but when and how, that's another matter. It is supposed to be discussed under the Space Resources Working Group in Vienna, also chaired by our friends, co-chair Stephen here. But I can see it's also very difficult to make a process there. Again, it is a challenge to all of us. But as lawyers, actually, we're supposed to be, how to say, to go ahead of our government on this. It's our duty to provide a specific and a workable, compromised, balanced framework for this. But that, again, as some of us just mentioned, it just needs another webinar to discuss on that. I just stop there. Thank you.
So I'm gonna, Franz, you talked about in the long run, this is all gonna be fine, right? In the long run, we'll have the norms. In the long run, but do we have that kind of time? And you're sitting back, you're seeing the ILRS, you're seeing the Artemis Accords. We're seeing, I think, just so the audience knows that there's a space resource. There's a working group at the Committee on the Peaceful Use of Outer Space on the legal aspects of space resource utilization. It has been very tough. The two of the greatest individuals I know in the lead, Stephen Freeland and I just completely blanked us, Mishtal. Yeah.
No, I don't want to. I don't want to engage in wishful thinking. You're absolutely right. It's a big question whether.
What can we do then? Like what is the next step? We're not the COPWIS, that working group, even under Mishtal and Freeland, is not making tremendous progress. We do have a new proposal by Romania for an action team. But But do we have that kind of time? We have commercial entities going, we have, 30 missions planned to the moon in the next 3 years. What
Yeah,
would
no,
you see?
I agree. Again, I don't want to do any wishful thinking, and it's a good question whether we do have the time. What I'm trying to say is that the moment that we see this whole discussion on due regard and harmful interference being applied to a more specific, concrete context, whether it's the lunar exploitation issue or the LEO concerns, that allows already to home in on sort of common interests. And again, it's no guarantee, and it absolutely doesn't mean that we can sit back and relax and forget our roles. But I do think there is a value and an interest in keeping the discussions alive, and it's going to be very interesting to see indeed how the Chinese-Russian developments in terms of the lunar exploitation, the ILRS, how they are going to develop. Because if you look at the Artemis Accords and the 30 plus, I don't know exactly the numbers right now, the 30 plus countries which have signed up to this, they already reflect a rather comprehensive number of states from various backgrounds. It's not just the Western states and the traditional US allies who have signed up to that. There are African countries, there are Latin American countries, there are Arab countries. There are a few big ones missing, of course, most notably China and Russia and maybe India. And that's why it would be so interesting to see if China and Russia are coming forward with similar principles under the ILRS. Then we see a sort of a very embryonic, given truly, baseline developing for discussions. Let's not forget that in 1967, the Outer Space Treaty was agreed between the two superpowers of the time who were locked in a Cold War, and yet they were able to agree on this for common interests. And even though the world is not as simple anymore, we now have a multipolar world, it still allows for possibilities to conduct these negotiations. And again, I'm very interested to see how the ILRS develops in that, because I sometimes facetiously say that there are basically two reasons why China does not join the Artemis Accords. One is, of course, the legal side of US government officials and agencies being basically prohibited at any substantive level to deal with the Chinese in space. And the other part is let's put it plain, is prestige. China is looking for its own role as a superpower, and that does mean that you cannot simply piggyback on a US initiative. You have to undertake your own initiative. But in terms of substance, there might be more similarities between the interests of China and the interests of the United States in how these regimes develop, because ultimately, again, we're all in the same boat. And again, you're right, Michelle, it doesn't entitle us to sit back and relax. And maybe we'll have to find that out, but maybe the time is too short for that. But on the other hand, it's still worthwhile taking the effort and continues to talk on these issues. I hope that sort of answers your question.
Yes, absolutely. So I just want to, again, housekeeping. So there are 43 signatories to the Artemis Accords right now, and India did sign the Artemis Accords. So I also wanted to, for people who don't know, Franz is talking about the Wolf Amendment in the United States, which doesn't outright prohibit, but states that if a U.S. government entity wants to work with China, you have to get special permission from the FBI and Congress. So yes, it in as much prohibits, but we do have some examples where there is a relationship between scientists with approval. So Jeremy, we're talking about how you talked about how we need to get essentially decisions made. This is a fact-specific circumstance. Do we really want to leave this to a ICJ decision? What is due regard? Or, is there a way to forestall that kind? I mean, I guess that's the question. Do we want an ICJ situation determining the way they did for the UN close? What is due regard in space? Is there a way we can forestall that? Or do we want to?
So much here. Yeah, I prefer to avoid an ICJ case. They're lots of work. Let's let's avoid situations where there's harmful interference, where there's sort of a cause. And in fact, that's why there's the consultation mechanism. Let's not think straight about going to the ICJ. Let's force the parties to talk to each other, the relevant parties. And there are so many steps that could happen, should happen, and there's an example, have to happen before you even sort of think about international dispute resolution. And there isn't even the sort of mechanism for that in the Outer Space Treaty itself. There's also, of course, the liability convention. There are some cases of harmful interference which will cause actual damage, and then there is a regime through the liability convention for that. So. But I think I do think it's sort of preferable that sort of state parties, the experts, the interested actors, whether they're lawyers or scientists or policymakers, and all of that who work in areas of space day to day, it's preferable for those actors to come up with the standards, the rules, the interpretations, rather than an ICJ, a tribunal that is, for whatever their strengths and weaknesses, are not going to be space experts, most if any of them. And so that's the sort of dialogue that is going on in different ways in different forums, and is so important to continue. On the Artemis Accords, as Franz mentioned, yes, there's a sort of a wide cross section of countries who have signed, and I think if you consider what they are, that's not in fact a surprise. They are grounded in the Outer Space Treaty. They are sort of fleshing out some of the concepts in the Outer Space Treaty. They're open to all. It's not a legal. They're in a legal framework as such, but they're rooted in the treaty, and I think it's very useful as a way of sort of building out some of these concepts, also as a forum for countries to put meat on the bones of what's deconfliction, what's avoiding harmful interference, and so on.
Thanks, Jeremy. So I just a reminder that if you have questions, I see there's a couple questions in the Q&A right now that we'll get to in a couple minutes. I wanted to ask, and this is open to all three of you, all questions are, but is there a role for a private company or private individual in this concept of due regard? So for example, as everyone knows, I am the president and CEO of For All Moonkind. So what if something happens to the Apollo lunar landing site and the United States doesn't feel like it can do anything? What if an area of the moon that the astronomers were hoping would remain pristine for far-side astronomy is impacted? And there can be an argument, well, just like you said, there's an argument that an ASAT test that balanced national security, there can be an argument that you're not balancing, because it's far more important to have a far-side telescope than it is to have whatever it is we can mine from the far side. Is there a role for private individuals in this scheme at all? And I want to bring up also the Navajo Nation. So as you know, in the United States, when Astrobotic launched to the moon, they were launching the remains of 60+ individuals, and the Navajo Nation objected to that. Now they objected within the US system, and they didn't have a lot of say within that US system. So are these individuals left out?
Michelle, that's a question to me?
Yeah, sure.
If I understand correctly, actually, it's also one of the worries from me. It's about, as we are space lawyers, of course, we know obligation of authorization and continuous supervision there, and another, I just mentioned, like the obligation of ushering. But I found Jeremy also introduced, actually no such kind of a specific saying about the requirements to non-government entities in Artemis Accords. Artemis Accords mentioned many requirements, say like data sharing, and even the Article 11, the Section 11 about safety zone. It does not expressly say whether a private company also is allowed to establish such kind of a safety zone. And what if, for all the moon kind or TCTV, we just established, such kind of zone around the telescope, as you said, or China, some Chinese company. So I'm afraid it would just make it more difficult, bring more uncertainties to all of us. I strongly agree with Jeremy just mentioned that the most urgent matter is about the establishment of coordinative mechanism in the government level, at the government level. Without such kind of coordination mechanism, it's hard to attribute, we say, the legal consequences brought by private actor on the moon to which government. Then it means some legal risks there. It's not good for the space industry either. So for both the spacefaring countries, United States, China, Russia, European countries, they must take some steps. As just France mentioned, they have to do something right now. Maybe it could be taken as a starting point. If it's hard to talk among the powers, then they can try to elaborate some kind of regulatory framework in domestic policies or law to provide more predictabilities in this case. I stop there.
And thank you for raising that, because that was the question. And Franz, you have done a lot of work with nations helping them develop their space law. Do you see a way to sort of incorporate these sort of very amorphous due regard obligations into national legislation?
I apologize. I think the answer is a typical lawyer's one, yes and no. It is easy to the extent that, and this to the extent that I have any impact on how these laws ultimately develop. I'm always advising is to refer to the terms of the Outer Space Treaty as much as possible. So it is an easy step to include in a national space law that you're only going to license and authorize space activities by the private sector, going also to Go Use Point, if they are going to operate in terms of the due regard for the corresponding interests of other states and their nationals, because it's interesting to note that Article 9 specifically also makes reference to states and their nationals. So they are part of the game, whether we like it or not. However, that's the yes, so it's easy. But on the other hand, that doesn't get us very far as long as we don't know what due regard means. And that's, of course, the problem, because if you are a company, you don't want to have a license telling you in very general, vague terms, this is what you need to do. But we're not able to tell you exactly what you need to do because we don't know ourselves. But that brings the problem back to the higher level. So in that sense, of course, the flip side of that is that if states do have a specific interest in developing a notion of due regard, or if they have specific versions of due regard in mind, they can thereby help shape the international interpretation. If they elaborate in the national law a specific version, a specific set of obligations or rights for licensed and authorized operators, that may help shape the international development. And it's interesting to note that I've worked with two countries in particular in the Arab world, the United Arab Emirates and Saudi Arabia. And we should realize that in the context of Islam, the moon has a special religious meaning. And it goes a little bit back also to, I guess, the Navajo issue there, which is, of course, beyond law as such. It has something to do with religion, philosophy, looking at sort of things beyond the law itself. And both countries have interpreted the requirement of Islam to honor the moon as a very important religious symbol as not impeding any potential commercial obligations, commercial operations and exportation, actually. So whereas it could have told them, we are not going to allow any operations on the moon because in our view, in our perspective, that is against Islam, they have not taken that stance. And that, of course, helps support the general sense of legality of commercial operations on the moon, of exportation on the moon. But I haven't seen anything to that extent in terms of due regard. So that's going back to your question, that's where the no still applies.
I like the idea that, or the concept that you point out, though, that if a nation does include something, they could be creating that framework for some norm, and that's what we hope we're doing with the One Small Step Act in the United States. Well, you had some more comments.
Yeah, thank you, Michelle. If I may just also hop pursuit there. I'm inspired by your question and the friends saying there. I think we should consider whether a national space law should contain the notion of due regard. I'm also, as you might know, I'm also one of the drafters of the Chinese national space law. It just, it has taken a long time. Of course, it's difficult. Personally, I suggested one article actually just almost reflect exactly what has been said in Article 9 regarding due regard. But some experts just were confused about that because due regard is general aspect to some engineers or some officials. Because my intention is to show to international community. You see, China is trying to implementing its international obligation under Article 6, right? To assure, because national law, of course, is supposed to be implemented by all the space actors under China's jurisdiction. So it's good. But on the other hand, I also understand because due regard, it is a notion, how to say, generated by political compromise concerns there. It's not only about safety, also actually about the security. It's not about only about the sustainability, it's also about the stability. So that's the saying use their corresponding interests. But at national level, we are supposed to have more specific, even more strict requirements to the space actors. I think it is two different things at national level or international level. So I think due regard, maybe the notion is not supposed to be exactly reflected in national law, but it must assure there are relevant articles to support the implementation of due regard, like the space debris mitigation requirements, notification requirements, or some other safety, measures there. So I just stop there. Yeah.
Of course, I have two sons that are engineers, and they roll their eyes every time I talk about due regard because all they see is more cost to them to meet those requirements and obligations. But yeah, so we still, and we're falling back to, we need that international framework. Jeremy, go ahead. You had some comments.
So you just mentioned mitigation guidelines, and that's such a great example of due regard at play in hopefully in national frameworks as well as international. The corresponding interest of all states not to have debris jeopardizing their missions, at the same time recognizing that debris can be an effect of even an ordinary flawless mission. And so, I mean, balancing is sometimes been used in this conversation as a as a dirty word, and yet it's necessary. We are trying to explore outer space, and we're trying to avoid harmful interference and so on. So I think mitigation guidelines in a national framework, and again internationally, is a great example. And the licensing regime, the authorization supervision regime at the national level, whether it uses the words due regard or not, certainly needs to be taking account of it. Just clearance of orbital flight paths, and where in space are you going, and how are you getting there through national airspace. That is, I think, due regard at play. Again, thinking of the requirements about avoiding harmful contamination, adverse changes on Earth. So I think a lot of national frameworks are taking account of that, and that the more technology develops, the more types of missions are flown, the more crowded it gets, and so on. These concepts are going to sort of evolve. But I do think it's there already, whether it has the label or not.
It's interesting because as we've gone through this conversation, I love this concept is balance, a dirty word. But and we talked about how due regard is a very fact specific, but it's also very activity specific. And so maybe rather than trying to, embrace and create a concept of due regard, it's very much more, okay, due regard in orbit means this with respect to debris remediation, and then it means this with respect to lunar activities. And hopefully, I know there was a question in the chat. There is a conference on Tuesday in advance of the Committee on the Peaceful Use of Outer Space on lunar resources, cislunar activities. And I believe the registration is still open for people who would like to participate online. And you would just go to the United Nations Office of Outer Space Affairs to find that link. And I encourage, if you have the time, to join that, because the lineup is amazing. And I think the different perspectives are going to be really fascinating. And I think it will inform a lot of what we think about due regard.
Can I just pick up on that really quickly,
Sure.
Michelle? Because I think you put your finger on a really important point when you say activities, and if we think about sort of types of activities, so fact specific, we really are talking about a very specific factual situation, an approach, or what have you. That's at a very sort of granular, specific level. Due regard, the treaty terms at a very sort of high level. There is a middle ground there where you can talk about types of activities, types of behaviors, where I do think there's opportunity to sort of flesh that out in common ways that that a lot of states sort of practice and understand.
This is a question, and I open it to all three of you, because I think it bears a little bit on how we navigate due regard, because it says, whatever happened to the Moon Treaty from the 1970s? What can we learn from the Moon Treaty, its existence, it's the fact that Saudi Arabia withdrew from it? What does it tell us about, or if anything, about due regard, or does it not offer any lessons whatsoever?
Well, as a professor of international law, I want to say that if a treaty is not signed by the major players, has not gained much attraction or attractiveness, even from various quarters across the globe in terms of the major players, we should be very careful in drawing too much conclusions, other than that apparently the text of the treaty didn't appeal to too many spacefaring nations. So if you talk about due regard, I mean, the Moon Treaty does two things, right? On the one hand, it simply implements and further elaborates to some extent some of the provisions of the Outer Space Treaty with regard to the specific context of the Moon. And those parts were not really controversial. So there we might find some support. But in particular, when it comes to the exploitation, obviously, with the common heritage of mankind discussion, that was what, in a sense, crippled the chances of the Moon Agreement to ever become clearly relevant. And to the extent that we're talking about due regard in a context of exploitation, and the safety zones, the discussion on notification and stuff like that, all having to do with the idea of actually settling on the moon and using its resources, I think there it will be very difficult to develop or to draw any valid conclusions from what the Moon Agreement says, other than those which simply repeat or reiterate what the Outer Space Treaty already says, simply because the Outer Space Treaty says it already.
Any other comments on?
Yeah, Michelle, if I may, yes, I agree with Franz that the Moon Agreement, of course, liking of the ratification from the major powers, it's a pity. But I would like to, how to say, we are teachers, we score our students, about their assignment performance. So Moon Agreement, if from 0 to 10, I would like to give 7, something between 7 to 8, because I was born at the year of the Moon Agreement, was endorsed. So there's some emotional things there. It's not about political things, because you see in copious United States, like some other countries, when they talk about space law, they only refers to the 4 UN treaties, but without mentioning the Moon Agreement. I think the reason has been mentioned by France. And as to some others like China, Russia, some other developed countries, they always mention the 5 space treaties. So the first point, I still think the Moon Agreement means a lot to us, to all of us. The first reason is at least it reflected the compromise, the consensus among all the countries, maybe 45 years ago, right? So even if, I mean, it was not ratified by the government for now, but at least it was, it has the consensus before. So the most difficult part actually is about interpretation of the common heritage of, we say, humankind, okay? So that's the main concerns. That's why I think United States just has the decorative order, I think number 6, maybe, 2020, I think. It would not like to talk about in the Moon Agreement. It did not take it as one of the parts of customary international law, and would not like to admit other spaces, global commons, whatever. But I can understand, because for all of us, I mean, for the space foreign countries, for the actors on the moon or would be on the moon, such kind of discussion means costs, political costs. It means a long, tough negotiation. So I can totally understand that people or government who would not like to talk about the Moon Agreement. But at least, although it does not provide many details about due regard, because that's not a focus of the Moon Agreement, it would like to open the door to provide the basis for exploitation, even for space mining in future. So I admire the drafters at that time. They are really smart, and because due regard is about the safety of activity. But at that time, people did not have so many knowledge about the specific activity in future on the moon. So this it is said that international regime must be established, shall be established when such kind of activity is feasible, becomes feasible. So it also, on the other hand, it means because it's coming, it's getting feasible, right? So now it's the right timing for all of us to consider like the Zuno measures, no matter it's a coordinative zone or safety zone, some kind of mechanisms like the interoperability or we say some other space debris mitigation measures right now should be discussed as to implementation of dual guard in lunar activities. I'll stop there.
Thank you. I'll go to Jeremy and then back to Franz.
So just quickly, I'm reluctant to speak about the Moon Treaty, which simply not knowing a great deal about it. So certainly the United States not being a party, but maybe one way to look at it is, as Franz was referring to its exploitation provisions, maybe it didn't get the balance right in terms of common exploitation, parties exploitation. Not sure, but likewise reluctant to speak about the Navajo Nation and so on, other than to say, because not being familiar with all the particulars there, other than to say that the sort of dialogue and consultation and engagement there is very important. So, thanks.
Thanks. Go ahead, Franz.
Yeah, thanks. Two points, and I hope, Guo, that you don't take this personal, because I didn't realize that the Moon Agreement is as old as you are. I can just say that you are much more successful than the Moon Agreement, so maybe that helps. But to be a little bit more serious, I still want to insist that if a treaty is, there may be initial agreement amongst the drafters, because otherwise the text in 1979 would never have been agreed to. But the fact that then all major spacefaring countries, and we always talk about the US not ratifying the Moon Agreement, but China has not taken any steps either. Russia, or at the time the Soviet Union, has not either. None of the major spacefaring countries has. You only have India and France at the time signing the treaty, but they never went ahead with actually ratifying that. And because the nature of international law is that you cannot unsign a treaty, you either have to then ratify and immediately withdraw, or you just leave it at that. I have questions about the extent to which you can even hold France and India liable to the general purposes and object of the treaty, which is what normally a signature without a ratification to a treaty means. But more seriously, I'm always a little bit wary about these discussions of using the Moon Agreement as an argument, in particular by countries who did not ratify themselves. I remember that when in 2015 the US announced its US Commercial Competitiveness Act, including the first set of articles allowing for commercial mining of the moon, that in particular the Russian Federation came forward and said this is in violation of the Moon Agreement, but the Moon Agreement was not ratified by Russia either. And it's a very fundamental principle of international law that as a state you can only legally argue on the basis of obligations and rights that you have yourself engaged in towards another party which has done the same. So that brings me to the second point. Yes, it's true that the Moon Agreement talks about an international regime, and it actually only then sets out a few very general principles which that international regime should comply with, which I don't need to go into any detail. My point being is that an international regime can also, the word international regime is as open to interpretations as is harmful or due. The ITU provides an international regime in a sense for how to run a commercial satellite operation, but it doesn't impinge upon the individual rights of sovereign states to license satellite operators to do so, as long as they stay within the process and the ITU regime of how to coordinate the use of satellite frequencies and orbits. So it leaves totally untouched the possibility of individual states to license private operators. And those who talk about an international regime following the moon usually, not all of them of course, but usually tend to mean by that you actually need an international licensing regime. That's where the reference to the deep seabed regime always comes into play. And I want to make clear that, you know, international regimes can be of either nature. So if you want to use the Moon Agreement as an argument for saying an international regime requires some form of an international set of boundary requirements, boundary legal conditions, that's fine with me. If you say an international regime and you mean you need international licensing, then I think that's where we sort of fundamentally disagree on what is legally required or possible. I stop there also in view of the time.
Go ahead, Guo Yu.
Thank you, Michelle. Just a quick response there. Suppose I were more successful than the Moon Agreement, only because I provide more details, you know, than it did. So I just it's not advertisement time, but I had a paper regarding the new or the dual interpretation of common heritage of mankind principle. It was published in Acta Astronautica, that journal. I'm trying to persuade all the governments, of course, for the spacefaring countries, including my own government, to reconsider. I understand the strong concern behind it, particularly from United States, the worry about how to say the moratorium, brought by any improper interpretation of this principle, because that principle is a cornerstone of the whole treaty. Also, talking about the international regime to be established, no matter under the Space Resources Working Group, Artemis Accords, or the international research, scientific research station. They must consider a basic principle, but right now it's just no such kind of discussion among the governments, so far. So that's the first point. And then actually such kind of a principle could be interpreted by practice, because the Moon Agreement, at least it does not provide the no matter ownership or property right over the abstracted resources. It's just talking about the, no claim ownership over the resources in place. All right, so it does not try to block the space mining or the space exploitation utilization activities, including commercial one. So again, it's the duty of our lawyers. We're supposed to provide more workable, balanced interpretation and to be considered by the government. So put Moon Agreement aside, it's an easy way, but for long run, actually, no one could benefit from it. It's really hard to establish a new treaty, a new legal regime, just regardless of what we have so far. I think it's not smart, and it is not pragmatical. I stop there.
No, I think that's very thought-provoking, Guoyu, and I think one of the concepts, again, is what Franz brought up, that common heritage of humankind. What does that mean? Does that, and I think in the US anyway, that means that you have to share your profits, and that's what people don't want to do. And so perhaps if we can come to some sort of agreement about legally what obligation is created by considering a domain the common heritage of humankind, then maybe we can resuscitate the Moon Agreement. But I think that would be just as difficult as drafting a whole new treaty. So we're down to 1 minute, and I'd like to give each of you an opportunity to wrap up your thoughts. So I will go ahead and start with you, Jeremy.
Sure. Well, thanks again for this great discussion. I know there have been some talk, maybe comments submitted online about is the Outer Space Treaty dead? I would say it's very much alive. This discussion shows that, and then events such as events such as instruments such as the Artemis Accords, long-term sustainability guidelines, norms, rules, principles for responsible behavior, all of those are sort of demonstrations that the treaty is alive, that the concept of due regard is alive, and that all of us can do more to sort of build scaffolding to support the treaty through efforts like those. Thanks.
Thank you, Jeremy. Franz?
Yes, I think the most important point to take away for me from our discussion is that we indeed do not need to see due regard as a comprehensive uniform monolithic concept which applies to all sorts of situations, because that's not helpful. I was very much triggered, Michelle and Jeremy, by the thoughts that no, we need to focus on the specific context. And I think if we focus on the two contexts which are currently most important, the LEO and space debris discussion, which we didn't touch upon much today, and the lunar discussion, that's where we do see some development further to space sustainability guidelines on the one hand, and Artemis and ILRS on the other hand. I think there is more progress possible in terms of honing in on what specifically due regard means then. So if we want to really make progress with these discussions, we need to keep in mind that due regard means different things in different contexts.
George Long, I see a lot more webinars in our future from due regard per activity. Guoyu, please.
Thank you, Michelle. I just enjoy a lot, from our discussion, and I'm inspired a lot as well. So just the first point, as I said, due regard is a balance between different values: safety, security, sustainability, and stability. So that's the first point. So it should be examined case by case in specific scenario. And second point, as to lunar activities, it might be easier because Article 4 just clearly stipulated lunar activity, right, is supposed to be exclusively for peaceful purpose. So maybe there lies security concerns, stability concerns, stable concerns here. But again, it's still debatable whether Article 4 provides non-military, 100% non-military legal requirements there. It's another debate, of course. And the last point, I think, how to apply due regard in lunar activity or, any other space activities is actually a matter about the personality. Just try to be a good person, And I remember you mentioned, in this instruction at the end of, you mentioned that self-restraint. I think is a super important thing, because for all the powers, I would like to say, their first feeling, they don't like rules. They don't like binding rules, particularly. Yes, okay, we can keep the flexibility there, but again, then it's a matter about themselves, how to perform, in a good manner. Even some activity, some behavior are not expressly banned or prohibited under international law, but they must consider about it, carefully. So that's my last saying in this case. Thank you.
Thank you. So I know we're out of time, but I just want to say I started out very curious. In the middle, I was terrified, and now I'm hopeful. So thank you very much. I want to thank all of you, Guoyu, Jeremy, Franz. I encourage the audience, if you're not familiar with these gentlemen, please look them up. They are incredible scholars and have a lot of work out there. And I want to thank George Long for putting this together, and to Lionel for doing all the behind the scenes tech work. We really appreciate it all, and thank you all for joining. And Guoyu, Franz, Jeremy, what an incredible conversation. The time flew for me, so thank you so much.